Or had been convicted of murder or manslaughter of the disease.
Oh, really?
Yeah. My name is Ade.
I'm Roxanne.
And together we're going to be taking you through issues arising from probate. You might have lost someone recently, or you might have been confounded, by issues regarding administration of another person's estate. If you've been to the bank, for instance, to ask questions about the person's account, I'm sure the bank must have mentioned something like, "Oh, sorry, we can't do much except you give us probate." And you are wondering, what exactly is probate? You've been on the internet, you've been looking, what can I do? What is probate? How do I go about it? This video is for you. So sit down while Roxanne and I take you through question and answer session on what probate is, what can be done, how you can do it, and what you need to do even after you've obtained probate.
So, Adi, could you explain to me what is probate?
Probate, simply put, is the authority to deal with someone's estate after their death. As you are aware, if someone dies or when someone dies, you are forbidden to dealing with their estate or touching their property or their asset wherever they might be until the assets are administered in accordance with the will. In case of a person with a will, or where there is no will, if they die intestate, then in accordance with the law. So probate is that document that gives you, the personal representative, usually when there is a will be the executor. If there is no will, it's going to be the next in line, the next of kin, the wife, the children, or if there are no children, then maybe parent. Yeah, so the list goes on and on. So they will be the one charged with the responsibility to obtain grant. Like I said, grant could be a probate when there is a will, and it could be letters of administration when there is no will.
Perfect. Thank you so much.
Yep.
Do I need probate when a loved one dies?
If the value of the estate of the loved ones is less than £5,000, then you don't need probate as a matter of law. But there are cases whereby the value is more than £5,000, and all you've got is the disease asset in a bank, which is more than £5,000, and the bank are willing to release such monies to you. I know for a fact that Barclays will probably give back to the family funds in their custody. That is within the threshold of, I think, 25 to 50.
Okay.
I know the banks nationwide to have their own threshold. I think it's 25. Some other banks will do 30, 40. Yeah, so it comes down to discretion of the bank. But in truth, they are not required to give you access to that person's account or their funds in the absence of probate if it's more than £5,000. So if it's more than £5,000, you must always get probate, except you fall under those categories I mentioned earlier, which is the bank using their discretion just to make things, move on smoothly, which happens more often than not. But if that's not the case, if the person has got a property, for instance, and then you have to sell or do something regarding that property, you don't have authority to deal with that estate except you have a grant or probate or letters of administration. So that's when you need a probate. You must get a probate when it's above 5,000. You don't need a probate when it's below 5,000. I hope that's clear.
Okay. And when must I apply for probate?
In truth, there is no time limit if inheritance tax is not payable. If inheritance tax is however payable, it's expected you start immediately, because you are expected to report the value of the estate to HMRC within 6 months. Failure to do that, the estate might be liable for penalty interest, and that's not something you as an executor, in case of a will, or you as an administrator of the estate wants to be liable for.
Okay, perfect.
Yeah.
What if the deceased had no will, like you said? Do I still need probate?
Yes, like I said, there are instances where a deceased will pass away without a will. In law, we say the person has died intestate. When someone died intestate, it means they've died without a will. But it doesn't mean you cannot apply for grant with respect to their estate. If they leave property, for instance, if they've got a house, if you've got monies in the bank, they've got investment, you will still need to administer that. And like I said earlier, you would have to go through a particular set of people who are entitled to take out probate in accordance with the law. Here, the operation of the law will take effect, which means it's going to be the wife. The person was married. If the person didn't have a wife or a spouse, as the case may be, then it must be the children. Where there are there were no children, there will be the parent. Absence of parent is going to be the siblings of the same blood. Absence of the siblings of the same blood is going to be siblings of the half blood. Absence of that, then you have the grandparent. Absence of grandparent, you have the uncles and aunties. Absence of that, you have the state. So it's a long list, and those are people who are entitled to take out probate in the event of the death of someone who has not made a will. But again, it's always advisable to make a will so you can avoid all this operation of law, because the truth is you wouldn't know what to do really if someone died without a will. It's going to be more difficult. You might need a solicitor to advise you or to help you with getting that letters of administration. It becomes more expensive, it becomes more complicated. So one way to simplify that is to always make sure there is a will. If there is a will, the possibility that you could do it yourself is there.
Perfect. Drawing from what you say, do I need a solicitor to apply for probate then?
If it's complicated, if the person died without a will, the possibility that you might need a solicitor, like what I've said now, on the nature of people who are entitled to take out probate, that's not something you probably get on the internet. And even if you do, you might not understand it. So you need a solicitor to break that down for you, to explain to you. And then you then need to make an application, because the likelihood that there will be many people, in case of children of the disease, there might be many people who are entitled, so you might not be able to use the online probate application procedure. That I'm going to get to soon, and I'll explain why I've said that. So so it might just get more complicated in the absence of a will, and even cases where there are will, if there are many properties or assets in the estate, it might also be ideal for you to get solicitors help, because you might need advice regarding inheritance tax and other things like that. So it's important to get this involved. But if it's simplified, you've got a will, you're talking about just one property or little money in the bank, then that's something you could do yourself without the help of a solicitor. And there are portals for individuals to make application. So this is something you could Google when the time comes. You go through the portal, it's self-explanatory, you create an account, and then you start the process.
Could you please explain the probate process as an individual for us?
Okay. When you are faced with the death of a loved one, the last thing you want to think about is applying for probate. A very long-winded process, so that you could deal with their property. So, which is why we always advise you pass this on to your solicitors if you have one, and if you believe the estate has got the money to deal with it. But we do understand monies are hard to come by these days, and there might be need for you to want to do this yourself, which is why we're doing this video in the first instance. So if you need to apply for probate, you must understand there are two ways you can do that. The first is you can apply online. There is an online portal where individual could go create an account, and then you just follow the process. It's very self-explanatory. You don't need much IT knowledge, for you to navigate this. And then there are cases or instances where you might not be able to use the online portal. In those cases, you have to use the paper application. So what are those cases you won't be able to use the online portal? Number one, if the deceased had made a foreign will. A foreign will is a will that probably done in another jurisdiction, and they concern properties here in England. In such case, you cannot use the online probate system. Or it could also be a case whereby they've already admitted that particular will to probate in that jurisdiction, and they're coming to the UK for resealing, or what we call second grant. Then you might not be able to use the online portal system. And again, we've had cases whereby the person applying, that's a personal representative, is been accused or had been convicted of murder or manslaughter of the disease.
Oh, really?
Yeah. So when things like that happen, they'll rather you send the paper application that's against applying online. And also, if the person died abroad, disease died abroad, you might have to apply online. There are other instances too, but these are the very foremost one. And it could also be the case if you don't have the original will. If you are making an application with a copy will, for instance, you will have to use the paper application. As a matter of fact, there are other things that are attached to that, but that's not the purpose of this video. That's a question you could ask us if you don't have the original will. What can you do? We'll be very happy to attend to your specific questions in that regard. So, having said that, that's how you apply. You apply using the online method at all time, except those instances that I mentioned, happens, and that's the way it works, really. So, having said that, you must understand that that's the process by which you enter information. But before you get those information, there are certain things you have to do, and this is what we call the probate process itself. The first thing you have to consider yourself fighting with is going to be you valuing and collecting the estate. You have to value the items or the properties of the estate. For instance, a real property, you get the estate agent in, they give you a valuation, and that's what you work with. There could be artifact, it could be other things in the estate that you might have to get a valuer to come in to look into. You get those values, you add them up. I haven't done the valuing, you're going to have what we call the list of assets and liabilities. And it's this information you take with you, and then you enter into your probate form, whether you're filling online or you're using a paper application. So I haven't done that. If you found whilst you're doing that, inheritance tax is payable, then what you do is that you complete the IHT 400 form with the necessary adjacent or attaching forms, and then you send them over, to HMRC. HMRC is the authority that deals with tax in the UK. Send them over to HMRC, and you wait at least 28 to 30 working days. And once they come back to you, or if they don't come back to you within that time, you can then go ahead to apply for probate. If you do it anytime earlier, your probate application might be delayed. So it's important you use that time you wait. So that's that in case where inheritance tax is payable. But when inheritance tax is not payable, even if the estate is up to 3 million, estates up to 3 million are considered to be accepted estate since 1st of January 2022. So if you have an accepted estate and you believe that inheritance tax is not payable, maybe because there is spouse exemption or other exemption, business reliefs or things that you will use that will knock off tax completely, then you don't have to complete any form. You don't have to complete. Before 1st of January 2022, we used to fill a form called the IC 205, but you don't need that anymore. Once you know that inheritance tax is not payable, all you have to do is to get the gross value of the estate, the net value of the estate, and the value of the estate when all the reliefs and the benefits, are applied. So that's all you need. Once you get those information, you go on your form, you put them in, because there is a column for them where those questions will be asked, whether you're completing online or you're completing using the paper application model. And then you complete this, you send it over. Once you send it over, you would be asked to download what we call the legal statement if you're using the online model. The legal statement is more like the witness statement, where you're saying everything I'm saying is true, nothing but truth and all that. So you have to sign it. You print that out, you sign it, and then once you sign it, you send that with a copy of the original will. Remember, I said if you don't have the original will, you can't use the online model. So you send that with a copy, with a copy of the original will, and also you send it with a copy of the death certificate. The death certificate, is not a copy; it's going to be original. The will also has to be original, not a copy of it. So you must send all of those with the cover note that you're going to be downloading and the legal statement in case of online application. Send it over to HMRC, and that's the end of that. All you have to do is just to wait. The wait time is between 8 to 16 weeks. Sometimes it's longer. Sometimes you could be lucky. It's shorter, and then you get it very quickly. With respect to paper application, it could take longer. Experience has shown that it takes longer, except you are in the habit of chasing them maybe on a weekly basis, and you could be able to get a quicker turnaround. We've seen this. This is why people employ the services of solicitors, because that's our job. We could have people dedicated, just chasing every other day, to make sure you get results as soon as possible. So that's that as far as a probate application is concerned.
You mentioned inheritance tax.
Yeah.
Could you explain it, please?
Okay. First, I have to put a caveat out there. We are famous solicitors. We're no accountants. So the advice we're giving is just what we know with respect to the applications we make. If you need proper advice on inheritance tax, my advice would be for you to consult with your accountant or financial expert. They will be able to help you further. But with respect to application for probate, or for letters of administration, one thing you have to bear in mind that everybody has got what we call the personal allowance of up to £325,000. So it means if, God forbid, you pass away and then the value of your estate is below £325,000, then nothing is payable on your estate as inheritance tax. But if it's the case that your estate, for instance, was £400,000, upon deduction of the 325, which is your personal allowance, the 75,000 left, you have to pay 40% of that as inheritance tax to the state. So inheritance tax is usually 40% of whatever is above that threshold.
Mm-hmm.
But again, there is a further band rate that you could take as benefit. For instance, if someone has got a property at the time of death and they lived in that property, they've got further relief of £175,000. We call it the residential nearer band rate. I don't want to start using all these terms because I don't want to confuse you any further. So, the first one is called nearer band rate. Nearer band rate, but I just call it personal allowance because I think it's better. You understand?
Easier.
Yeah, it's easier because it's what we all have, whether you own a property or not. But if you then own a property and you live in that property at the time of death, then you have an extra £175,000. So if you add the £325,000 to £175,000, then that increases it to £500,000. So what it simply means is that if you own a property at the time of death, then any value of your estate up to 500,000, you don't pay inheritance tax on it. But anything above that, say it's 510,000, then you pay 40% as inheritance tax. In case of 510,000, your inheritance tax payable will be £4,000 because that's 40% of the extra 10,000 above the 500. I hope that makes sense. So that's everything as far as inheritance tax is concerned that you might be able to understand. There are other things in terms of things you can use to knock it off or to knock it down. But like I said, that's this is not the video for it. If you need any personal, tailor-made or tailor-specific information on inheritance tax or how to apply these reliefs, because there are a lot of reliefs, but I'm not mentioning them yet, because they're just going to unnecessarily complicate this whole video. Yeah, so you contact us, send us an email, and then we'll be able to answer you with the right information for you.
Yes, definitely. But what happens after the grant is issued then?
Once grant is issued, this is where the work starts. In case of someone with will, what you have to do, first you pay up any debt in the estate, if there is any, and wherever is left, you distribute in accordance with the will. So you can distribute if the will says, "Oh, give this to this, give that to that." They are called personal bequeather. You give that to whoever has been mentioned in the will, and then there will be a part of the will that says the remainder should be shared, amongst this person.
Yeah.
Those ones are called the residuary beneficiaries.
Okay.
So then you also go ahead to share things in accordance with whatever the will says about residuary beneficiaries. And so that's the end once you do that. You can see that's very simple because you have a will. But in the case where you don't have a will, it becomes complicated. You remember what I said about who is entitled to take out letters of administration? The same thing applies here. In the same order with which people were entitled to take out the grant of application, the same list will apply when it comes to how you share in the estate of the deceased. So in case of a deceased that has got a wife and children, the deceased personal asset will go to the wife, and then the wife will take what we call statutory legacy of 322,000, and whatever is left will be shared equally between the wife and the children. I don't know if that makes sense. What I'm saying is, if the deceased has got personal property like laptop, things like that, they go to the wife. And then if the estate, for instance, is £1 million, the first £322,000 will be paid to the wife. And whatever is left, you slash it into two. You give one half to the wife, the other half you share amongst the children. Even if they are 50, they have to share that. So that's what the law says. But in the case whereby someone dies without children, then the spouse takes everything. So, and in the case whereby someone dies without a spouse, maybe their spouse predeceased them, died before them, then the children will take everything. They'll share it equally amongst themselves. But what happens again when there are no children? Remember what we said earlier? Then this is where the parent will come in, and the parent will share, between themselves equally, if both of them were available at the relevant time. If not, whoever is available will take the entire share of that estate. But what happens when there are no parents? Then you talk about the siblings of the same blood. If there are no siblings of the same blood, you get siblings of our blood. They all share equally also. If there are no siblings of our blood or the same blood, what then happens? You go to grandparents. If there were no grandparents, you go to uncles and aunties. If there are no uncles, then it goes to the state, which we call bona vacantia, meaning wherever you own, if they are unable to trace family member or relatives, will be taken over by the state. We've seen cases where this happened. We will just pray it could be avoided. You making a simple will would avoid that, because then you could then have more control over how your asset is distributed, upon your passing. Yeah, so that's that you need to know about probate, its application, what happens after you've concluded the process, and if you have any question, which you definitely must, because this is not exhaustive. This is something we discussed with clients for over 2 hours, trying to make them understand. So I'm not silly to start assuming that you will take in everything in just 20-minute video. No, of course not. This is just information for you to get started. If you need more information, please do contact us. Our contact details are right just in our description. Look at it, contact us, and everybody's waiting to hear from you, and we'll be very happy, to come back to you very quickly. If you remember, we said we give free 10 minutes advice to the first 10 subscribers that ask us questions about the video of the day. So if you ask us any question, Roxanne, myself, and the rest of the team are waiting, and then we'll be able to answer your question specifically. Again, do not put any personal question on the comment section for your data protection purposes. That's not wise. Contact us via the email details provided to you, and we'll be able to take it. For you to get this benefit, you must subscribe. Subscribe to the channel. Let's grow the channel, and let's help you. Let's help ourselves too, because we're happy helping you, and then we'll be able to bring more video to you. So if this video has been of any help, you could help someone too by sharing. On my note, I'd like to say thank you for listening.
Thank you for watching.
I know it's a long video. We'll see you next week.
Bye.
Take care. Bye.